This conference will now be recorded.
Thank you. All right, and just one more reminder to please put yourself on mute while the presentation's happening. And so I'm going to get started here. Let me try opening up the slides I've put together. And I am going to ask if people don't mind to take notes and on any questions that you have as I go through these slides. But we are going to try to save the questions until the end of the presentation. It's a pretty quick presentation. I think it'll be about half an hour, and then that will leave us plenty of time for question and answer afterwards. So give me a second. I'm gonna work on sharing my screen. Okay, can everyone see that?
Yes.
Okay, great. So Rule 2, this is all about the updates that take effect on Wednesday of next week, January 18th, 2023. So here's what we're going to cover. I'm going to give a general overview of the changes that were made to Rule 2, to our rules of procedure. I'm going to dig in a little bit more on the specific parts of the rule. So we'll talk about changes to Rule 2.100, which addresses the scope and construction of rules. Changes to Rule 2.200. This is where most of the changes happen. These are the procedures generally applicable, and that's the bulk of Rule 2. And then changes to Rule 2.300, which deals with consumer complaints. And then changes to Rule 2.400, which addresses other matters such as injunctions and temporary restraining orders. And then we're going to have a question and answer session at the end of that. So I want to give some important disclaimers at the beginning, and apologies for reading off the screen, but I just want to make sure we're all on the same page of what I'm covering this afternoon and what's not being addressed. So as noted here, the Public Utility Commission does not provide legal advice to persons that may appear before us. This presentation is not legal advice. The contents of this presentation are intended for general information purposes only. Do not consider anything in this presentation as a substitute for obtaining legal advice from a qualified attorney, and do not act or refrain from acting based on the information in this presentation. In short, don't quote this presentation. Commission Rule 2 speaks for itself, and any interpretation of Rule 2 can only occur by commission order. This presentation does not expand, contract, or provide any formal interpretation of Rule 2. Also, Rule 2 will change because it will be updated periodically. And finally, this presentation is not intended to be comprehensive. So the updates to Rule 2, the final version is nearly 70 pages long, and I'm not going to attempt to cover all that here. This is just a big picture overview, and the idea is to give everyone an idea of where to find the updated language in Rule 2 itself. So for a general overview of the changes that were made, if you take away nothing else from this presentation, take away this, that 3 documents, Commission Rule 2, are standards and procedures applicable to electronic filings using ePUC, and the Vermont Rules of Civil Procedure are all being combined and replaced by the updated Commission Rule 2. So starting Wednesday of next week, January 18th, there shouldn't be citations to the Vermont Rules of Civil Procedure or to our standards and procedures for electronic filings. Everything should be referring to Commission Rule 2. So I want to talk a little about the process and how we got here. most of Rule 2 had not been updated in many, many years, but we've had some big changes at the commission during that time. Act 174 called on the commission to make changes that would facilitate public participation in our proceedings. EPUC came about and went live in 2017, and that created our online case management system. And just in the last few years, we've had a number of significant changes that resulted from COVID-19. The biggest one being the changeover to remote hearings, remote proceedings. So in August of 2020, we began this process. Commission staff had put together proposed changes to Rule 2, and we put that out in the informal rulemaking process to stakeholders and anyone who is interested in participating. And we received a number of comments in multiple rounds of comments. We held multiple workshops. And during the course of that process, we significantly redrafted the proposed changes. The biggest change was we received feedback from stakeholders that there is interest in incorporating the rules of civil procedure directly into Rule 2 to provide everyone with one document that they could have rather than the 3 separate documents that had been in place. And so we received those comments, we addressed them in the informal rulemaking process. That continued through the formal rulemaking process, which was recently completed, and that's how we got to the rule that goes into effect on January 18th. And finally, I have on here, I want to give a big thank you and express my gratitude to all the participants in this process. Many of you are here on this call this afternoon. And I want to also thank the other commission staff who worked on updating this rule. We have them on the call this afternoon as well. Ann Bishop, John Cotter, and Mike Towsley. And I'll also note Ann, Mike, and John may jump in at any time if as I'm going through this presentation, and I encourage the 3 of them to jump in if I misstate anything. They've been involved all the way through this process and know the changes well. Okay, so I'll jump right into the changes to Rule 2.100. The 2 biggest changes are, as I mentioned, the Vermont Rules of Civil Procedure no longer apply. Rather, the relevant portions of those rules have been directly placed into Rule 2. And the other big change is all filings must now be in EPUC. We do have some exceptions, for instance, public comments, consumer complaints, and confidential filings are not, don't go through EPUC for confidential filings. The public comments and consumer complaints can be done through EPUC, but they also can be done through email or paper filings. And then we have some other minor changes to Rule 2.100. We have a number of new definitions in there, including we've defined the term final order. And we've also clarified how to seek waivers of a rule. So that's done through motions. If you have an ongoing proceeding, a motion in that proceeding to seek a waiver of a rule is what we'd be looking for. If there's no open proceeding and someone's seeking a waiver, then that's done by petition. And the rules explain what need to be included in the waiver, which is a concise explanation of the basis for the requested waiver. So more in Rule 2.100 and the change to have the rules of civil procedure no longer apply. So the rule that's in place currently, but is going to be changed next week, it says that the rules of civil procedure apply to our proceedings. And now we've taken the language from the applicable rules of civil procedure and placed that into Rule 2. So I give as an example, a motion to alter or amend an order, more colloquially known as a motion for reconsideration. Currently, that type of motion would reference Vermont Rule of Civil Procedure 59. But starting January 18th, that type of motion should reference Commission Rule 2.221. Not all of the rules of civil procedure have been incorporated. We tried to streamline the rules to just incorporate the relevant ones. And we've made cosmetic changes. For instance, any reference to court was replaced with the term commission. But there are some substantive changes as well to the rules of civil procedure that we incorporated. And case law from the commission and from courts that interpret related provisions of the Vermont Rules of Civil Procedure is still going to be relevant precedent in interpreting these rules. So if someone files a motion to reconsider, the case law interpreting Rule 59 of the Vermont Rules of Civil Procedure on the standard for a motion for reconsideration, that case law is all still going to be applicable. And finally, parties can request waivers in particular proceedings so that the entirety or certain provisions of the Vermont Rules of Civil Procedure apply. We don't anticipate that happening, but that is in the rule that's an option for parties if they think it's important to have the Vermont Rules of Civil Procedure apply. So moving on to Rule 2.200, this is where the bulk of the changes are, and there are many significant changes. I'm just going to hit a few of them here.
Private closed, what county was that?
And just a reminder to make sure to hit mute if you're on the call. We got to have a little background noise.
Who is the Hardwick town? Okay.
All right. Oh, I'm sorry, everyone. Went through a bunch of slides. Okay. So in 2.200, we've clarified when and how representation by non-attorneys can occur. We've simplified the process for substitutions of appearance. There's no longer going to be a need to file a motion to withdraw. And we've also allowed non-substantive ex parte communications with the clerk or other administrative employees regarding procedural, scheduling, technological, or administrative matters. So that's just clarifying that it's okay for someone to call up the clerk and ask when a hearing's happening, is that hearing going to be remote or is it in person? Things like that. We're just making clear in the rules that that type of communication is allowed. But again, it needs to be non-substantive and it needs to only be with the clerk or other administrative employees. So non-substantive meaning it shouldn't get into any facts or law involving the case. We're now going to have page limits on most filings, though there are some exceptions there. Any motion must state whether the other party's consent to the relief requested. And the standard for intervention is relaxed to mirror the standard for court proceedings. The standard deadline for objecting to testimony has been changed. Under the old rule, the deadline was usually 30 days after testimony was filed. Under the new rule, parties will have until 14 days before the hearing starts, generally. And there are many more changes. I'm going to go through each of the 30 sub rules of 2.200, but again, I'm just highlighting a subset of the changes so people have an idea of where to look. Okay, so Rule 2.201, this has new provisions that net metering system installer representatives can make filings and what's required for those filings. It talks about pro se and non-attorney representatives, out-of-state attorneys, substitutions of appearance, and this also has the new provisions on ex parte communications. And just, I should have mentioned when I was talking about ex parte communications, the term ex parte refers to one entity, one party having a communication with the commission where the other parties are not involved. And so that in general, ex parte communications are not allowed for any of our contested cases. And so the updates to the rules just clarify when someone can contact the clerk's office about certain things. 2.202, this is where we've codified that all filings must be an EPUC with limited exceptions. There's a new waiver form for people seeking a waiver of that requirement. The preferred format of filings seeking to initiate enforcement proceedings is spelled out in that rule as well. 2.203 makes clear electronic signatures are allowed and that that's a certification of the factual and legal basis of the filing. 2.204 has the requirements for making certain filings for service of process, for certificates of service. This is where we have the general 25-page limit on filings, a 15-page limit for responses, a 10-page limit for replies. But there are exceptions, notably the proposed orders, proposed findings of fact, and pre and post hearing briefs are not subject to those limits. 2.205 has some special notice requirements for any proposed changes to poll attachment terms or tariffs. 2.206 addresses expedited motions. Those need to be clearly marked. And this has the new requirement that motions must state whether other parties consent to the requested relief. 2.207 is where we talk about computing time. We've kept the 4:30 deadline, and we're sticking with what the courts are doing of what's called the day is a day rule for counting days. Motions to extend deadlines must be filed at least 3 days before the deadline happens. 2.208 has provisions for when the commission can reject filings as deficient. 2.209 is the new standard on intervention, which is now modeled after the civil court standard, or Rule 24 of the Vermont Rules of Civil Procedure. And one of those changes includes the elimination of the requirement that a proceeding be the exclusive means for a party to get the relief it's seeking. And there's a requirement that motions to intervene must be timely. 2.210 talks about joinder. When starting a case, all necessary parties need to be included. There are other provisions on joinder in there. 2.211 is on consolidating hearings. 2.212 says the commission can order mediation on its own or at the request of a party. 2.213 has requirements for pre-filed testimony, and also says that in lieu of notarization, someone's main testimony can include a declaration, but they must use the exact words that appear in Rule 2.213. 2.214 says that discovery must follow the provisions of 2.230. And we'll get to 2.230 in a minute, but that's where pretty much all the provisions on discovery have been placed. And this was intentionally done so that for proceedings where discovery is not occurring, parties can.
Oh my gosh, did you just fall asleep?
We do have some background noise.
I felt like I was listening to stereo instructions.
Anne, is there a way we can actually automatically mute someone?
No, but let me see what I can do.
Okay, thanks. Sorry about that.
Our little speaker thingamabobber, it should have big blinking.
So all right. Anyway, we've put 2.230, the discovery provisions, at the very end of the rule, so that if you're not getting into discovery in your case, you don't need to look at those provisions. And discovery request must be filed in EPUC, and if the commission requests that responses be filed, those also must be filed with the commission. 2.215 incorporates our updated ex parte rules for commission witnesses. And again, only non-substantive procedural scheduling and administrative discussions are allowed. Okay, 2.216 on remote proceedings. We'll see if this works. Just a quick moment of levity during this long presentation. I think many of you have already seen this video before.
It was me. You just hung up on me. I know. Why is my speaker?
Kyle, I'm not hearing the sound. I'm not sure if anyone else is having the problem, but I can't hear the sound from the video.
All right, sorry the sound wasn't working. Yeah, that was the famous I am not a cat video. So it's just a reminder, we now have in Rule 2 specific provisions on remote hearings. We have not prohibited people from using cat filters, but it's not recommended. So that's in 2.216, the provisions on remote proceedings. And this also has the new deadline for raising objections to pre-filed testimony, and a definition of when the record closes. Rule 2.217 says that during an evidentiary hearing, objections must be raised immediately, and has more details on how to do that. 2.218 has the subpoena requirements, and also has a rule about, in general, you can't subpoena non-testifying members of the public, such as those who file public comments. 2.219 is our summary judgment provisions, and for those filings of summary judgment, oppositions are due 30 days later, replies are due 14 days later. And there's also a provision that bad faith declarations can lead to an imposition of cost on the party that had the bad faith declarations, that they'd have to actually pay for the other side's costs in responding to that. Rule 2.220 has provisions on withdrawing petitions, and it also says that the withdrawal of net metering registrations is automatic if a registrant fails to respond to a utility's objection. Rule 2.221 covers motions to reconsider, motions for relief from judgment, and harmless error. So those are provisions that correspond to Vermont Rules of Civil Procedure 59, 60, and 61. 2.222 has requirements for proposed findings of fact. 2.223 has requirements for briefs, and the font size, the typeface, things like that, and it includes a requirement that briefs longer than 10 pages must have a table of contents. 224 has provisions on sanctions, and those can include directives of a non-monetary nature. Penalty provisions can be included. 2.225 says that the parties must work together to try to jointly file a proposed schedule as soon as possible in a proceeding and no later than 3 days before a scheduling conference. So I do want to highlight that one because it's not uncommon that we get a proposed schedule from parties the day before, 2 days before a scheduling conference, but the rule is clear that those need to be filed at least 3 days before. And it has a list of items to include. All right, almost done. The 2.226 covers the requirements for filing confidential documents. Again, these are not done in EPUC. It's done through an email to the clerk with a clear marking of the document as confidential. And at the time it's filed, there must also be a public version filed in EPUC, either a redacted version, or if the entirety of the document is confidential, then a filing that states that a confidential document was filed. And the confidential documents must include a cover letter citing the ruling that makes clear it's already been held to be confidential, or a motion seeking confidential treatment. 2.227 says that during a declared state of emergency, the commission may issue orders temporarily altering these procedural requirements. 2.228 has provisions on motions to recuse a commissioner or a hearing officer. Those motions must be filed as soon as a party is aware of a potential conflict. And there's also a provision for situations where a commissioner or a hearing officer discloses a potential basis for recusal, and then there's a 7-day clock that starts for parties to file a motion to recuse if they think that person should be recused. 2.229 says the recordings of proceedings is generally allowed, but must be disclosed at the beginning of the proceeding. They must not interfere with the proceeding, and they cannot capture private discussions. So any recording can't capture a discussion between an attorney and their client, and can't capture discussions among commissioners and commission staff. 2.230, this is the very long part of the rule that includes the specific discovery procedures and which ones apply, how they apply. It has limitations. For instance, depositions now must be 7 hours or less, and it has provisions for discovery sanctions as well. So Rule 2.300 on consumer complaints has just minor language changes, and it notes that complaints are often referred to the Department of Public Service, but if it's not referred to the department, then the commission will provide notice to the subject of the complaint and any affected utility. And then finally, Rule 2.400, proceedings other than consumer complaints. This has specific requirements for injunctions and temporary restraining orders. It has a much longer list of forms that must be used for certain filings, for instance, the notice of intervention form. And there's a new section 2.408 on the commission's authority to take emergency action when the governor has proclaimed a state of emergency. So that can be done by petition or motion or on the commission's own initiative, and the specific requirements for those emergency actions are spelled out in that rule. And finally, on next steps, I want to make sure everyone's aware we have a number of standards and procedures that are being updated to reflect the new Rule 2. We have a new order coming out on the filing of annual reports by utilities, and we have a number of new forms that are going to be on the website live when the new rule goes into effect, and some other forms that will be removed from the website because they're no longer applicable. Okay, I hope that was helpful. Sorry for not having the audio on the cat video, but and again, like I said, it's not in the weeds. This is not the details of the rule. It's 70 pages long, so you have to look at the rule itself for those details. But the idea here is just to give everyone a general overview of where to find the new provisions. And now I'm happy to take any questions that people have. And I think what I'll do is I'll stop sharing my screen and then we can all see each other a little better. Okay. So if you have any questions, you can just unmute and start speaking. You have Allison Rose, did you have a question? Or Mariah Fraga or Morris Silver, those are the unmuted people I'm seeing. Bill Ellis, anyone jump in if you have a question.
Hi, this is Tina Rabideau on the line. Can you hear me?
Yes, yeah, go
Okay,
ahead.
great. Okay, sorry. This is just a minor question that I have is administratively. I was curious to know on the rule, I guess it's I wrote it down, 2.204 ED, when it talks about headings on documents. I'm curious to know if they're supposed to be 12 font, and if single space is still okay. That's typically what we use is 12 is the single space, but I wasn't sure if the headings on documents should, on like the subsequent pages, should be in 12 font or 10 font.
Okay, let me just check if I can. I think that, so we have provisions on using size 12 font for the text in the document itself and double spacing the text in the document itself, having at least 1-inch margins. In terms of the headers that go on the top of each page, I don't think we specified the font size or anything like that. I think it's more important that we actually have the specific information on there, like the case number and such, as I recall. But John or Mike can chime in if they remember something different.
My memory matches yours, Kyle, that we did not specify a font size for the headings.
Okay, thank you. Do you have a preference, or you're going to leave that to each person's?
Yeah, I don't think we have a preference. I think it's usually headers do have smaller font to get the information in there without bleeding onto the text of the document. So that would be fine.
Okay, and my second question actually relates to footers, footnotes. Same thing. The number of the footnote, is there a preference for the size of that font? And then the text for the footnote, is there a specific font size you would like for that? Or are you also leaving that to the individual preparing the document?
I don't think there's a preference on that. I think, yeah, it's not uncommon for footnotes to be font size 10 or 11. I wouldn't go below 10 on anything because then it's hard to read.
Okay, thank you.
Mm-hmm.
And then I have one last question with respect to affidavits on the signature block. Is there a requirement for affidavits in terms of what is required to include, besides the person's name who's signing the affidavit? do you require the address, phone number, and email of that person as well on affidavits? I was just a little unclear when I was reading through if that was also required on affidavits. I know it is on pleadings, but I wasn't sure on affidavits.
Yeah, I don't think we made any changes to that I can recall. But I do know the main change we made here was for filings where an affidavit is required, we have a provision for using a declaration instead of an affidavit, and that's where you need to make sure to use the exact words that appear in the rule. I think that's in 2.213 is where those provisions apply.
Okay. Thank you very much. Those are the only questions I have.
Sure. Anyone else have questions?
This is Annette Smith. Those were very good questions. Thank you, Tina.
Oh,
So, sort of along those lines, I often see filings that don't comply with the rules. They don't have headers. So is there any enforcement of the sort of that aspect of the rule?
Yeah, that's a fair question. I mean, we do have the ability to reject filings that are deficient. I think that you're right. As a practical matter, that's more likely to occur when there's a substantive deficiency. So I guess what I would say is that these are the new rules. We do expect all participants to follow these requirements. It is always fine to contact the clerk's office if there are questions that about how to comply with a provision of the rule, like the questions we just got about footnotes and headers. We do expect parties and participants to look in the rule itself to try to find those answers before contacting the clerk's office. But the expectation is that the filings meet these requirements. I think that as a practical matter, I'm not sure to what extent the commission is going to reject filings or let parties know when filings are incorrect. I guess I'll just put out there that our hope is that with these revised rules, parties will take another look at what they need to do to make sure filings are in compliance. Any other questions? All right, well, thank you everyone for your time this afternoon. I hope this was helpful. As I mentioned, this presentation's been recorded, and so it'll be available if you want to look at another part of it later on. Let me just open it up quickly for other commission staff. Ms. Bishop, Mr. Tousley, or Mr. Cotter, if you have anything you want to make sure gets mentioned before we wrap up. All right, hearing nothing further. Thank you again, everyone, and hope you enjoy the rest of your day.
thank you.